Before we go ahead and break down the rule and start talking about the different subsections, let's talk about another problem here, and that is dual role testimony. So the first thing we talked about, again, is the wolf in sheep's clothing, and here the government is trying to go ahead and bring testimony that is really expert testimony through a lay person. This is a little bit different. What happens here is that the prosecutor will try to go ahead and use an expert to testify as both a lay witness, lay in the sense of a fact witness, testifying as as to the things that that they saw, he or she saw, or observed or whatever during the process of the investigation. Now, and this is not categorically prohibited by the rules, but it is fraught with tremendous danger, and we have to be ever vigilant against this. This is a typical technique that the government has. It is a dirty technique, and we gotta call them on it whenever it happens. Now, so here, we introduce another character in the cast of characters of the low rent, budget circus, and this is the jack of all trades. Now, let's look at a great example on this one, and this is the Garcia case. And we all have had a case like this. So, here, the defendant is charged with conspiracy and possession with intent to distribute heroin. So here, the district court allows an FBI agent to testify as an expert on this is on drug-related conversations, deciphering the conversations, and all that. I mean, you think that this person is like a code breaker type thing. And then the court also allowed the same individual to go ahead and testify as a fact witness regarding the investigation. This is just not some FBI expert that the government pulled in to talk about this narrow issue. This person was involved in the investigation itself. So you have somebody that's essentially wearing two separate hats, two roles. The defendant, of course, here is convicted, because of what, the testimony the district court ended up allowing. Let's see what the Fourth Circuit, has to say about this. So the Fourth Circuit here says that in a situation like this, where you have the government trying to bring in a witness that's going to be testifying in two separate roles, as a fact witness and as an expert, a court has to take a number of steps to protect the rights of the defendant. And those steps can include requiring that the witness testify as to the different roles at different times to make sure that, okay, now you're testifying as an expert and now you're testifying as a fact witness. Okay, so that's one step that the circuit says should be taken. Another one is using cautionary instructions, and then requiring that the government ground their question on either a fact question or based on expertise, to make it very clear to the jury what is going on. This witness now is testifying as a fact witness. This witness now is testifying as an expert, to try to distinguish that, okay? All right, now, then we have witness must be qualified as an expert. That's really the first requirement under 702. And, and just a couple of preliminary things here. The witness can qualify as an expert based on knowledge, skill, expertise, training, or education. There's, in essence, 5 different ways of doing it. Now, of course, a judge is supposed to determine whether the proffered expert is qualified. And then the burden, of course, rests with the proponent of the evidence. Now, the problem is that this is one of the big issues that's going on right now, is that that judges are misstepping on both those two steps, and we'll talk about that in just a moment. Now, these are a few arguments that we can raise whenever we got an expert as far as the issue of qualification. One, and that is that the expert is not qualified because the expert's experience is not relevant. The expert's experience in the relevant area is shallow or anecdotal. and all this I have, again, this is in my book. The expert lacks recent experience, and the expert has provided no methodology or guiding principles that will support her opinions. So those are some of the principal arguments that we can go ahead and raise dealing with the expert's lack of qualifications. So here we get to go ahead and meet another one of our friends as far as the gallery or the cast of characters from the low rent budget circus. This is the huckster, okay? The huckster. And later on we'll meet the snake oil salesman. It's a close relative of the huckster, but a little bit different. And we'll talk about that in just a moment. So this case here is fantastic, and it really, illustrates this point, as well as touching upon other issues dealing with 702. Very, very good case. Now, here what happened is that the defendants are charged with conspiracy and intent to distribute meth. Now, what happened is that because of a minor traffic infraction, the car in which the defendant and the driver are stopped. So the officers see one of the defendants, and she was shaking and reading from a sheet. Well, they look at the sheet, and the sheet is a prayer. And the prayer is in full in the opinion. The prayer is to the Santa Muerte, or the Holy Spirit of death. Okay? Now, so what happens here, this is like, it's just really pretty unbelievable. And again, this should be the subject of some Netflix show, is that this court permits this witness that the government is offering and supposedly is on religious iconography. That's what the field of expertise of the expert. And this expert, who's a U.S. Marshal for crying out loud, is testifying that the Santa Muerte is connected intimately with drug trafficking. And the mere fact that this woman was reading this prayer, that was certainly evidence that needed to be considered in the determination of whether she was guilty or not. She's convicted at trial and receives a brutal amount of time, of course, as in most of these cases. Now, the 10th Circuit here, looks at the case and makes a number of observations that are really pretty excellent. This is a really, really good case. But just two that are pretty significant. One is that the expert provided absolutely no methodology whatsoever. Okay? Instead, the problem that the district court had, and the reason why the district court went ahead and found what it did, is the problems that recur in cases dealing with forensics throughout the whole country, at a federal or state level. And one is that the court puts